My name is Joseph Kreps. I'm a traffic violation defense attorney. We help commercial driver's license holders in the state of Alabama who have been charged with a traffic offense here. I want to talk to you today about the federal masking provisions in 49 CFR 384.226. And that section is entitled Prohibition against Masking Convictions. It's important to note here, in order for it to be masking, there has to be a conviction. There is a group out there, the National Judicial College, that educates judges about commercial driver's license laws and has a resource page for them. And on that page is lots of very useful information. And there's a very insightful, very powerful question from a judge that was asked back in sometime probably after November 2008. And this judge had attended the seminar that is done yearly by the National Judicial College regarding CDL issues. And he mentions that at the seminar in November of 2008, that there was a presentation about masking convictions for over-the-road truckers, and that would just indicate a CDL holder. This judge mentions that there's in his jurisdiction, there's an interstate, and that there's a huge hill that these truck drivers have to travel down in order to pass through his jurisdiction. And essentially, there are quite a few cases in his court for violations where truck drivers are going faster than the posted speed limit. And he mentions that there's been a backlog of the docket. There's lots of trials. The prosecutor and the judge had gotten together, and it seems like they were reducing some of the speeds, etc. And the judge's concern is the same as every other judge's concern, and they were reducing these down to 14 over the limit, which saves a serious violation against the commercial license, which is something that is a very good result for a lawyer handling these type of cases. The judge basically says that he knows that this keeps the speeding ticket out of the major or serious traffic violations that would have an impact on the commercial license of the driver. And the judge says, just like most judges out there will, because they've been provided this information, the judge says, I don't want to get the state of Colorado into trouble with USDOT or any other agency. And he's asking the question for that reason. So he says, look, I want to do the right thing. I don't want to get the state in trouble. Tell me what I need to do. And he says after attending the class, he decided instead of reducing them to 44 and a 30, he decided he would do 45 and a 30. And it increased the docket. It was causing a backlog of trials, etc., etc. So the Federal Motor Carrier Safety Administration responded, and through the senior transportation specialist of the CDL division of the Federal Motor Carrier Safety Administration, this is the man who answers these questions on behalf of this organization. He tells the judge, from the scenarios you have presented, it would not be masking in either case, reducing it to 14 over or reducing it to 15 over, based on the description of masking in the federal regulations under 49 CFR 384.226. Plea bargaining to reduce the charge before it goes to court and a determination is made is outside of the scope of masking. It would be masking if there was a deferment of judgment or the driver is allowed to enter into a diversion program. And he also says he commends the judge on the stand to 15 over, but even if he reduced it to 14 over, it would still be plea bargaining and not masking. So it's very important to note that the senior transportation specialist says that this is not in violation of the masking provision. Missouri requested information about this as well, and they provided a scenario where a charge had been filed with the court and was later amended to 5 miles per hour over instead of 15 over, and the Federal Motor Carrier Safety Administration ruled that, or provided information that that would not be masking either, because it was done prior to a judgment of guilt. Prior to a judgment of guilt. And it's important to remember that there has to be a judgment of guilt before masking provisions and the prohibition against masking comes into play. My name's Joseph Kreps. I'm an Alabama traffic violation defense attorney. If you have a commercial license and you have been charged with a violation in the state of Alabama, we want to talk to you. All you have to do is call our office. You can reach us at 866-348-2889. You can also visit our website at trafficticketattorneyinalabama.com. We have handled thousands of traffic tickets in the state of Alabama, and we can help you. Do not simply go online and plead guilty and pay your ticket, because it will come back to cause you trouble in the future, whether with your employer, with trying to get another job, a new employer, with your license. It's just not worth it. You need to do everything you can to give yourself the best chance of success. Again, you can reach us at 866-348-2889. Thank you very much.